Welcome to Lecture 10. This week we're focusing on plea bargaining. I need to remind you that our trial process is founded on the idea of an adversarial system with the defense attorney and the prosecutor battling each other to convince the jury of their own version of the truth, and this process is mediated by a judge. This is what we see on all these TV dramas dealing with trials and things like that, but that's not the reality of the real criminal justice system. The reality of the real criminal courtroom is cooperation rather than adversarial. Plea bargaining is how we resolve 90% of the criminal cases processed by the criminal justice system, not by trial, but by the defendant pleading guilty, usually after some negotiation over what the sentence will be if they plead guilty. So defense attorneys realize that the majority of their clients are guilty. There was sufficient evidence against them. They wouldn't have been arrested otherwise, and the case wouldn't have proceeded through the courts unless there was enough evidence to constitute probable cause in the eyes of the judge. So clearly there's evidence against them. Most of them are repeat offenders, and it's obvious they're guilty. They can't produce credible witnesses or evidence in their defense. If they get on the witness stand themselves, they'll probably be very poor witnesses for their own defense. And most of them can't afford the cost of a trial. So therefore, defense attorneys take the strategy to negotiate the lightest sentence possible for their clients. They're not out to prove their client's innocent. In most cases, in criminal cases, they're trying to just get the best deal possible for their clients. So they have to negotiate a sentence with the prosecutor, preferably for the lowest amount of time of incarceration or the least burden on the defendant. And then they need to turn around and convince their client to accept this, because it's based on the client actually pleading guilty in the courtroom. And they will only do that if they're willing to accept the offer that's been made by the prosecutor. On the prosecutor's side of plea bargaining, prosecutors are evaluated on their conviction rates. So they need to get as many defendants to plead guilty or cases won at trial as possible. Yet they also realize that their agency has limited resources. It costs a lot of money to go to trial, so they can't afford too many trials. They only have so much money for the agency. Also, witnesses can be fickle. Sometimes they'll say the same things they did when the police interviewed them. It may be a year later we go to trial and they may have changed their story. They may have gotten criminal charges of their own. They may have died. They may have moved. So it's difficult to base your case on these witnesses. And juries can come to some pretty odd conclusions. Some real notable examples are Casey Anthony trial, the O.J. Simpson trial. Some of these cases that were slam dunks that all the evidence shows they're guilty and the jury still acquits. So it's sometimes dangerous and risky to go to trial. So therefore, prosecutors are motivated to offer lesser sentences or reduce charges in order to gain a maximum number of convictions with least expenditure of financial resources by their agency. So they're very motivated to handle cases through plea bargains as well. So while negotiating plea agreements, the parties involved, prosecutor and defense attorney, and sometimes the judge is involved in this. It may involve adjusting the charges in the case and or the conditions of the sentence. So say, for instance, you've got someone who was arrested for drunk driving, resisting arrest, assault on a police officer, and driving while suspended. As part of the plea bargain, you may be willing to drop some of the charges. So say, for instance, if he pleads guilty to the DUI and the driving while suspended, we'll drop all the other charges. So that's one way you can negotiate this process. And the other way is through what the conditions of the sentence are. So say, for instance, for the DUI, in the law books, maximum punishment could be 1 year of incarceration. You can negotiate, well, instead of 1 year in jail, we're going to request that they do 2 years of probation and attend drug counseling. So stuff like that. It can be used to negotiate the sentence. Second, while negotiating guilty pleas, the parties involved are aware that the process itself has punished the defendant to some extent. For instance, if the person was arrested, booked into jail, and then it took them a while to be able to bond out, that probably cost them their job if they were employed, if they've sat in jail for 10 days trying to raise the money for bail. Just having to come up with the money for bail to bond out of jail costs them financially. Having to hire a defense attorney costs them money. The more and more this drags on with the stress involved, and every single time they have a court appearance with a continuance, that's more money they've had to pay out for their attorney. So part of what goes into the mindset of the parties when they're doing these negotiations is how much has this defendant already suffered just by the process alone. And if this is dragged out for quite some time and they've lost an awful lot of money from this and they didn't have much money to begin with, that makes the prosecutor more likely to give in to a lighter sentence. Next, while negotiating plea bargains, the parties consider the going rate for the type of crime involved. If you go from community to community and look within a community, say for instance you take Lucas County Municipal Court and look at everyone arrested for DUI and all the pleas of guilty for DUI and what sentence did they get. What you'll find is for the misdemeanor DUI charge, almost everybody got the exact same sentence if it was through a plea bargain, that they probably all got 2 years of probation and drug and alcohol counseling. And that becomes the going rate. They're saying that one DUI is just like the next, it's just like the next. So we process them all the same to try to give some sort of fairness and equality among defendants. Now, sometimes there's some mitigating circumstance that might qualify them for a more serious punishment or a less serious punishment, but in most cases, they go by a going rate. Lastly, while negotiating plea bargains, the parties involved believe that a trial penalty exists for defendants who go to trial without substantial evidence of their innocence. What that means is, if it's a toss-up, you could be guilty, could be not guilty, and you go to trial, and you're found guilty at trial, and the sentence comes from the judge at that point, because it went to trial, the judge will take into account all the facts and circumstances of the case and the defendant's background and things like that when developing the sentence. However, the belief is that if the defendant goes to trial and they know they're guilty and all the evidence is stacked against them and they really don't have any evidence in their defense, and then they're found guilty at trial, the judge will punish them for wasting the court's time with not having a real case to stand on, and will give them a longer sentence, usually a much longer sentence, a more severe sentence than they would have gotten if they had just accepted a plea bargain. So the judges do this to deter people from going to trial unless they can really prove that they are not guilty, and tries to encourage as many defendants in as many cases as possible to be resolved through a plea bargain. So the first reading for this week is a very famous article. It's actually a chapter from a book called The Process is the Punishment, and this particular chapter is Handling Cases in the Lower Criminal Court by Malcolm Feely. Malcolm Feely is a world-renowned scholar who studies the courts and court processes. And this basically goes into what the prosecutor and defense attorney take into consideration, that just going through the criminal justice process, even if you're not guilty, exacts a toll, a punishment. It costs time away from work, time away from family. It's a long and difficult process. So when we're negotiating penalties and sentences, we usually take this into account. The next reading is another book chapter, this one by Milton Human, another law scholar, and it's adapting to plea bargaining from the prosecutor's perspective. And this article will describe to you why prosecutors are motivated to plea bargain and how they do that and what they take into account. And it's basically from the perspective of brand new prosecutors, people who have just graduated from law school and are in their first job as prosecutors. And keep in mind, for those of you that are interested in going to law school or may be in law school right now, realizing that this is what practicing law is really all about. It is not trials, it's the plea bargaining process. And it's a real eye-opening experience for people who are aren't familiar with that system. Third reading is The Practice of Law as a Confidence Game, Organizational Co-optation of a Profession by Abraham Blumberg. Abraham Blumberg was a law scholar and sociologist, and this article, although old, is still very accurate today. And it's basically the plea bargaining process from the defense attorney's perspective. And Abraham Blumberg was a sociologist and had been a defense attorney. And it's all about the whole process of, not only do you have to negotiate with the prosecutor to get them to give you a low sentence, then you have to turn around and sell this product to your client. So you're basically being a salesperson, trying to get or a broker of justice is probably a better way to describe it, to get the best deal possible for your client, but then turn around and try to sell it to your client that, hey, you're not going to be not guilty. You're going to have to serve a punishment because you are guilty. So here's the best deal I could get you, and try to get them willing to accept that. And then the last reading article is Plea Bargaining in the Shadow of the Trial, a Mirage by Sean Bushway, who's a professor at State University of New York, Albany, a major PhD criminal justice program, and Allison Redlick, who at that time was his graduate assistant. And it basically looks at this trial penalty. Does this trial penalty really exist? If cases do go to trial and there wasn't sufficient evidence, do they really get more severe punishments for that? So as always, don't forget the quiz at the end of the week 10 quiz, and email me when you have questions and problems.